is Hans von Spakovsky from, and I'm very excited about this, he's the senior fellow here, the senior legal fellow. Thank you so much for coming on at Advancing American Freedom. Hans, give me your rundown on James Comey in this case.
Well, look, he has shown that he is a crass partisan who he basically abused his power when he was the head of the FBI, and he should never, ever be given a position of public trust in the government again. I got to tell you, I think the grand jury indictment is a very weak case. There's all kinds of really nasty things people can say that's covered by the First Amendment, and you have to go pretty far before it can be considered an actual physical threat against somebody. And despite like I said, just the total inappropriateness of what he did, I still think he's within his First Amendment rights to have done that.
Yeah, I do too, unfortunately. Hey, I wanted to ask you though, Hans, since we're on this topic, we've been talking a lot about Jimmy Kimmel and his joke about Melania, which I also think is covered under the First Amendment. What is the line though? Because sometimes when I'm talking about these things on the air and I hear someone like Hassan Piker, for example, say the streets need to run red with their blood, or someone needs to do it, or you hear people kind of advising on the best way to kill the president or what they want to see happen. Where, as a legal fellow, where does that differ? Where's the point where you go, okay, now you're getting yourself into trouble? That's where it goes from protected speech to actual threats.
That is often a very tough line to draw, but the difference is, look, if you give a speech saying, boy, I really don't like this president, the country would be much better off if, somebody got rid of him, that's unfortunately within the First Amendment. If, on the other hand, you give a speech in which you say, I'm telling people in this room, you need to go out and you need to put together a plan to kill the president. In other words, they are urging people to engage in violence. They are doing everything they can to persuade people to engage in violence. That, I think, actually goes over the line, and that's when you can be prosecuted. But as you say, sometimes that's a tough line to draw.
Yeah, and since you brought this up, wasn't that exactly what Democrats were trying to do with Trump with his speech on January 6th, despite the fact that he said specifically go peacefully and protest peacefully? He made a point to just kind of cover his own ass there and say, I don't want any violence to break out, go peacefully. And they still tried to put him through the ringer for it and claim that he was inciting violence.
No, that you're bringing that up. That's exactly right. And he was not inciting violence. He was telling people to engage in their First Amendment right to protest, but to do it peacefully. And there was no way that was a criminal violation of the law, even though that's what Democrats tried to claim.
All right, now, Hans, I know that you are on here today to talk about something very important that happened with the Supreme Court. They struck down Louisiana's congressional map, and they found that the state's second majority black district violated the Equal Protection Clause. Can you run this through in simple terms for us, for people who are watching, for people who are seeing the gerrymandering going on and kind of these redistricting fights that are happening across the country? What does this mean for other states, and break down how they came to this conclusion, this 6-3 decision?
Louisiana has 6 congressional seats. When they redrew their maps, they made one of them a majority black district. They were sued, and a court said, decades ago, you guys engaged in racial discrimination in Louisiana, and black voters are a third of the state, so you have to create a second district. So the Louisiana legislature created a second black district, and they used race to draw those lines. They were sued again. And this time people said, look, you can't use race, and that order by that other judge was improper. The Supreme Court agreed and said you can't use race unless it is to remedy specific, proven, intentional racial discrimination. And that wasn't the case in Louisiana. And in fact, they gave a warning to courts saying that, look, when you're evaluating evidence of supposed intentional racial discrimination, you have to disentangle race from politics. And what they meant by that is, look, you and I both know what 95% of black Americans vote for the Democratic Party. Well, that's not a violation of the Voting Rights Act if, for example, they're all put together in one district because Republicans are trying to draw districts that favor Republicans. They are voting together not because of race, but because of politics. And you can't use that kind of partisanship to claim there's some kind of violation of the Voting Rights Act. Oh, by the way, the other thing they said, which makes perfect sense, is if you're going to show a violation of that law, you got to show current discrimination. You can't rely on what happened during the American Civil War or what was happening in 1965. You have to base it on current conditions, all of which makes perfect sense.
Well, what do you see happening next now that we have this decision? Are there other states that are going to take a cue here and make some sort of legal challenges? Or, like, what do you think the next step is now that we have this?
Well, this is going to change the whole redistricting litigation process. You know, every time states do redistricting, they are constantly getting sued. But what's been happening for years is that Democrats, mostly liberals, when they're upset about partisan redistricting, they try to claim that it's racial discrimination, racial redistricting, and therefore a violation of the Voting Rights Act. This decision is going to make it much tougher for them to make those kind of claims, and frankly, it should probably reduce the litigation that's filed when legislatures engage in redistricting. But it also is going to make it much tougher for states like California to do redistricting based on race, which is frankly what they did when they redrew the state earlier this year to compete with what they claimed Texas was doing.
Hans, do you have anything else you want to add in here from listening to these arguments, from reading these decisions about this situation in Louisiana? Is anything else standing out to you that you think the audience should be privy to?
Look, the Supreme Court's going to get criticized by the left. That's already happening. People should not listen to that criticism because what the court did is proper. They said, yeah, the Voting Rights Act is still in place, but if you're going to sue under it, you got to prove that there was intentional discrimination. And like I said, you can't rely on what happened, 50, 100 years ago because we're a different America today. And that makes perfect sense.
And Hans, this is a little off topic, but I have another question for you. So yesterday I was playing a sound. I don't know if you saw this. There was a back and forth between Lee Zeldin, the EPA administrator, and Rosa DeLauro. Did you see this back and forth by chance?
I read about it. I didn't see it.
Yeah, and he was basically asking her, like, well, do you know about this Supreme Court decision? Do you know about this Supreme Court decision? Because a lot of that it affects the EPA's limits and what they can do regarding climate change. And she had no idea. And this is something I'm seeing a lot now with, I would argue, more Democrat politicians than Republican. But it seems like a lot of these lawmakers don't actually want to do any of the reading here. They don't want to open up that thick binder full of decisions and kind of material and go through it. As someone who's so entrenched in the legalese of all these things and has a real understanding of it, does that scare you when you see people who are holding so much power in Congress have such limited knowledge on what's actually going on with these cases?
It does, but it's also no surprise because remember, Democratic legislators, they believe that there is no limit on their power. There's no limit on what Congress can do. They've shown that in in session after session, bill after bill. Do you remember when Nancy Pelosi, when they were passing Obamacare, and somebody asked her about the Constitution and its limits on the power of Congress, and she basically said, "Huh? What are you talking about?"
We have to pass the law so we can see what's in it. It was something along those lines.
Yeah, right. And, it scares me because, look, they want to pack the court, the left does, so that there won't be any justices on the court able to stop any exercise of power that they think is the thing to do. And that's one of the reasons why, like I said, they're really pushing and are very upset over the fact that we finally have a majority of justices on the court who actually are willing to step in and say, hey, the government can't do this.
Hans von Spakovsky, I thank you so much for coming. Please tell people where they can follow you, where they can read all your work, and give yourself a nice plug here.
Sure, they can go to Advancing American Freedom or at H. von Spakovsky on X, and they'll see all the stuff that I put out.
I really appreciate it, Hans. Thank you for your time and your wisdom on all of these cases. When we come back,